Practicing personal injury law is an interesting thing to do with one's life. Every case is different, and every client is unique. Some of the cases are interesting for a variety of reasons. One of the things that makes each case different are the unique markers for each client. The age that they are, what their previous health was, how the accident took place, and the complicating factors that we run into along the way. I'm going to be telling you about a case today about a lady that we'll refer to as Dina. She was an octogenarian. She was in her mid-80s when she had an unfortunate fall down a series of steps leading into a sanctuary of a church in her community where she was attending a cultural musical festival. She had a horrific set of injuries from this fall down several stairs. Multiple bones broken, her knee, her forearm, her elbow, her collarbone. She spent, I think it was 5 or more months in a variety of medical facilities recovering from her surgery and these horrific set of injuries. Like a lot of people in the geriatric population, she had a number of health issues that a lot of elderly people will deal with. She had arthritis, and who doesn't after they're above the age of 40? She had low bone density, so her bones were prone to fracture easily. Even though she was in her mid-80s, she basically ambulated without the need for any assistance. From time to time, as her arthritis would flare up, she'd use a walker, but she did not use a cane. She functioned at a very high level before her accident. The liability situation in Dina's case was quite interesting because the insurance company, as often can occur, denied that they were liable. They insured the church. And it was for the following reasons. So I want to give you a bit of the perspective of the insurance company and the argument that they made to us. First of all, there was an elevator available for people going to this music festival in the church sanctuary. So my client didn't really have to walk down any steps. She could have gone on an elevator. Unfortunately, my client didn't know there was an elevator available. There's 2 ways to get into the church, and the way that she got into the church, there was no elevator in sight nor any signs for the elevator, so bliss is ignorance, and she didn't know that another alternative was available. The insurance company also argued that my client was not looking where she was going. No one else had fallen that day, and so the argument went. As often is true in a liability situation where it's contested, we hired an expert. They were called a forensic engineer, and we hired them to look into the condition of the church and was it safe for people entering onto the premises. And the engineer made a number of very interesting observations. He said, first of all, that the lighting where the steps were located was very dim. It wasn't bright enough. In fact, our client didn't see the steps. The problem is she had just emerged from outside her community. She'd taken a taxi to the church, and it was a very bright, sunny day. And have you ever gone from a bright, sunny condition into a somewhat darker building? It's almost like you're blinded for a moment because your eyes are adjusting to the difference in luminosity inside the building versus outside, and that's exactly what happened to her. She came very quickly to the area where the steps were, but she couldn't see them because she was still blinded from the sunny outside conditions. The other problem is there was no volunteer that met her to tell her where to go, to tell her that there was an elevator available should she choose to use it, or to say, be careful ma'am, there's steps there, or anything like that. The other problem that the engineer discovered is that there was no adequate lighting on the steps themselves. You know how sometimes when you're in a theater, you'll see lights that are actually lit on the edge of each step to just kind of warn the patrons as they go up or down the steps. There was no demarcation of a different color of carpeting. The railing was inadequate, etc. But here's where we ran into a complicating factor. because these renovations done to the church were done decades before my client fell. And in Ontario, there's something called an Ontario Building Code, which explains what the minimum standards are for conforming with various building regulations. But we couldn't find out exactly when the renovations were done or what building code was in force, or whether in fact the municipality had adopted that Ontario Building Code in accordance with their municipal standards. So we were, pardon the pun, shooting in the dark a bit in terms of what the applicable legislation was. But notwithstanding that, the building code is only a guide. It doesn't determine the issue entirely. It's just a minimum standard that a municipality or another authority needs to abide by. Another complication we ran into is that our client went from a position of being highly functioning and independent to very dependent on the care of others, particularly her children. Well, the insurance company argued that my old gal should go into a nursing home. It was a lot cheaper than maintaining her existence in her own home. But I argued she didn't ask for this action to take place. A defendant has to take a plaintiff the way they find them, and she was entitled to stay in her home. So we looked into the law, and the law is quite interesting as it applies to these different fact situations. And the first question we had to answer was, should Dina have expected to encounter a step before she did? We looked at a fairly recent decision of a court case in Ontario in 2015 by the name of Gnys. And it involved an inadequately lit commercial premise, and the trial judge said this: the plaintiff had no reason to anticipate a step. She testified that she was not aware of the presence or existence of the step. In another case that the judge cited, quote, mere forgetfulness or want of attention, failure to look for some source of danger that is not present to the mind of the injured person is not contributory negligence. There was no warning or visual clue as to the change in elevation that caused the fall, such as grip tape, that would have drawn the plaintiff's attention to the hazard. The lighting was such that the change in elevation was not discernible. Absent any visual clue, which the plaintiff either ignored or failed to observe, I conclude the defendant has not proved on the balance of probabilities that the plaintiff failed to take reasonable care for her own safety. I therefore decline to assign any responsibility to the plaintiff for the injury she suffered when she fell. So this case was very helpful to Dina. It verified that she did not anticipate a step, nor was it reasonable for her to do so when she didn't see one. And she didn't see one because it was so dark. The next question that we had to examine, which was supported by law that we were able to determine, was whether Dina's injuries were worth any less because she was already in her 80s. The insurance company, and in fact the insurance industry, has a bias against elderly people. And they will argue that someone's injuries, if they're in their 70s or 80s, is worth less than if they're in their 20s or 30s, because after all, a young person has all of their years ahead of them and they're going to have to suffer for a longer period of time. Is that true? Is this something that the court will sanction? Well, it was my position that her injuries shouldn't be worth any less because she was in her 80s. And this is what we call the golden years principle. And there's a case, in fact, it's involving an elderly plaintiff, and the judge said this: what must be looked at is the deprivation of the vigor the plaintiff had enjoyed up until the accident, and which, on the evidence, I think he might have expected to enjoy for some long years. Injury to older people is, from at least one vantage, more profound than injury to the younger. And then the Court of Appeal in England, in a case by the name of Frank and Cox, was cited by that judge, and this quote is also of interest. I take the view myself that when one has a person in advancing years, in some respects, an impairment of movement may perhaps be more serious than it is with a younger person. It is true, as Mr. Chedlow, the plaintiff in that case, has stressed, that he has not got as many years before him through which he has to live with this discomfort, pain, and impairment of movement. But It is important to bear in mind that as one advances in life's own pleasures and activities become particularly more limited, and any substantial impairment in the limited amount of activity and movement which a person can undertake, in my view, becomes all the more serious on that account. In other words, if you're an elderly person and you suffer a serious injury, the effect on you is so much more than if you're younger, because you have much less margin to draw on. A younger person is much more easily able to adapt to an injury than an elderly person can. So our case, when we originally presented our offer, was $389,000 or so. The initial offer came in the low $200,000 range, and eventually we were able to settle with the church's insurer for approximately $340,000. So here are the takeaways from Dina's case. The first one is that you have to know the facts, particularly the more complicated liability may be. The more that fault is going to be questioned and fought by an insurer, the more careful you have to be with investigating exactly what happened. In this case, we were able to do a detailed investigation, and we came up with the statements of 2 eyewitnesses whose statements were extremely helpful to our case. In fact, one of the statements, believe it or not, was from a man who said he himself almost fell going down those steps because he was blinded when he came into the church building. So it was a great statement. So eyewitness statements are important. Another takeaway is the central role that an expert can play in supporting case theories. For example, our forensic engineer who supported our view as to liability. And lastly, just the sad reality that the insurance industry will routinely discriminate against the elderly when it comes to valuing their claims, compared with if a younger person was the accident victim. And I say that is just not right. And we were able to wrestle justice for this elderly gal that I came very much to admire. And the case ended well.